Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Thank you. Good afternoon, everyone. Our last case for today is State versus Ricks, and we'll hear from the appellant.
May it please the court. I am Teresa Postel with the Department of Justice, and I represent the state. This is the State versus Ricks, and I would like to reserve 10 minutes for rebuttal, please. I know my time is running, but before I actually begin my argument, I do want to note 2 points. On page 2 of the state's brief, this actually was a bench trial rather than a jury trial. And on page 13, I cited Rule 21E, which is directed at review of MARs. So aside from generally indicating a lack of appropriate circumstance, 21E I do not think directly applies here. The issue in this case is whether the Court of Appeals majority erred by reversing the trial court's SBM order. It did. But this case is not just about an SBM order. This case is about allowing exceptions to swallow the rules. The majority's 2 primary errors are in allowing exceptions to swallow these 2 rules, and those extraordinary exceptions were using Rule 2 and certiorari review, particularly being used here together. Uncorrected, the majority opinion here makes our rules that are meant to be mandatory meaningless, and it puts parties who follow them parties who fail to follow them, in a better position than those who do. The majority erroneously suspended the mandatory rules of appellate procedure and granted itself jurisdiction to vacate a trial court's order that the defendant had neither objected to nor appealed.
Ms. Postel, before you get too much further in here, I want to make sure I understand what's actually before us.
Yes, sir.
If I'm reading the record correctly, the only 2 issues that are really before us are, one, did the Court of Appeals err by granting writ of certiorari? And secondly, did the Court of Appeals err by invoking its authority under Rule 2? Is that what's before us?
That's correct, Your Honor.
So that's what we need to focus on, not other things.
That's correct.
Okay, all right, thank you. That's what I thought, but I wasn't sure.
By invoking Rule 2 and granting certiorari, those 2 extraordinary measures to overlook the rules of appellate procedure and this court's precedent, that's where the Court of Appeals erred in this case. The way they erred in doing that is that they granted itself jurisdiction and for a case to handle a case that the defendant himself had not even appealed. And it also invoked Rule 2 to avoid waiver because the defendant had never even preserved that issue in the first instance. This case warranted neither of those extraordinary measures, but the majority still exhausted them to help the defendant. The result is a use of these exceptions, which undermines the court's foundational law and the rules of appellate procedure. This defendant was convicted of 5 sexually violent, aggravated, reportable sexual abuse crimes against children who were under the age of 13 and by an adult, and an additional 3 indecent liberties with a minor. Defendant repeatedly in this case sexually abused these 2 6th grade children until he was caught at 3 a.m. one morning and physically confronted, and he left his DNA inside one of those 2 children. Those 8 criminal convictions against these 2 children, after being convicted for those, the defendant raised no opposition whatsoever to the SBM order. Not timely, not specific, not constitutional, not an objection in any respect. And the defendant furthermore did not appeal the SBM order, not orally, not in writing, not time. So this case is about following the mandatory rules and this court's precedent and the rules of appellate procedure. As the dissent explained, the Court of Appeals does not sit as an advocate for one of the parties. Its duty is to follow the law and to enforce the rules of appellate procedure. And the point of our preservation requirements is embodied in countless cases, as well as in Rule 10. It is to prevent appellate review of arguments that have not been thoroughly resolved and in the particular context for which the specific challenge was made in the trial court. These preservation requirements are so very important that in order to obtain appellate review, the challenge must be timely and specific, and it's limited on appeal to only the same argument that was made opposing that trial court decision in the trial court. It's so fundamental that even constitutional claims, even in death penalty cases, these waiver requirements apply in all of those instances. The importance of enforcement of these preservation requirements and waiver affects criminal law, civil law, and federal habeas review. So it goes far beyond just a simple SBM order. Without waiver, the incentive to argue the issues in the trial court where the trial court can address the particular challenge is lost. And worse, it incentivizes a strategy to avoid preservation by putting those who preserve issues at a disadvantage on appeal. In a rare case with unique circumstances that are distinguishable from other cases, Rule 2 does provide a possibility for review, but that requires an extraordinary step of suspending the fundamental mandatory Rule 10 preservation requirements.
Ms. Pascal, I'm sorry if I can stop you there. Can an appellate court invoke Rule 2 prior to granting a PWC?
I don't see how, because without granting the petition for cert, there is no jurisdiction.
Okay.
So no. So the answer is no, because the only thing an appellate court can do is dismiss that appeal at that point.
Okay, and to grant a PWC, there has to be some merit to the argument below, or
Yes, Your Honor. There has to be merit and there has to be diligence.
If an argument is not preserved, does that argument have merit?
It does not, because without preservation, there's no means for review at all. It's in this particular case, in fact, it was entirely waived because there wasn't some sort of objection to SBM. There wasn't an objection on statutory grounds. There wasn't a constitutional objection. There wasn't an objection as to efficacy. There was no objection whatsoever. So there's no way to get to merit in that instance.
Is the state's argument then that it's not permissible to use Rule 2 to reach the merits of an unpreserved claim?
Well, no, because that's separate. That's Bursell, right? So in Bursell, the defendant.
And that's why I was asking the question, because it seems to me that if the claim is preserved, then there's no reason to worry about Rule 2.
Right. So the defendant in Bursell actually appealed. So there was no question, there was no need for extending a second extraordinary measure to the defendant in Bursell because he appealed properly in writing and timely. But the defendant here didn't do that. So while Rule 2 can be used in exceptional and certain circumstances that are distinguishable from the regular constitutional issue or case, it's not available when there's no jurisdiction in the first instance. And the Court of Appeals knew that. And I believe the Court of Appeals actually addressed the Rule 2 issue first, and maybe for that reason. But the Court of Appeals can't do that, as Chief Justice Newby pointed out, because at that point, without jurisdiction, the only authority the Court of Appeals has is, in fact, a mandate to dismiss that appeal.
So would the outcome, in your view, be different in the event that the Court of Appeals had addressed whether to grant certiorari in the opinion at an earlier stage than would be the case when they address Rule 2? In other words, it matters. It's dispositive as to what order the two questions are addressed in an opinion?
No, I don't think that's dispositive. I just think it's incorrect to jump to Rule 2 without jurisdiction. In this case, there's still no reason, there's you don't actually, there's no trigger to grant certiorari unless there's merit. And so without merit, there's also the loss of the potential for certiorari, because certiorari is also a discretionary, extraordinary measure to be taken. There has to be diligence as well as merit. And in this case, there's neither. So the general rule, of course, is that
Let me stop you for a second and ask you about, and correct me if I'm wrong about this, but as I understood, what happened is that the defendant gave oral notice of appeal to the judgments entered in the criminal matters at the end of the trial. Is that?
So the defendant gave notice of appeal of his criminal conviction.
Right.
He did not give notice of appeal of the SBM order. And if there had been any confusion about whether that notice of appeal could have possibly applied to both, in the record, the defendant has inserted on page 55 a statement that the notice of appeal that was given in the trial court, that oral notice on that transcript page, was actually a Rule 4 notice of appeal for the criminal conviction. And that's on the record at page 55. So there actually was no oral or written notice of appeal of the SBM order at all.
Right, but just to be clear, the judgment and commitment as well as the SBM order and registration, et cetera, were all entered on the same day, under the same proceeding. Are they?
Well, they are at the same time, and I don't mean to quibble with you at all, because I agree that yes, first is the trial. The judgment was entered on the criminal conviction, but of course it has to be a separate hearing for the civil part of registration and satellite monitoring. So it was separate, but it certainly followed immediately.
Right. You're not contending that the Court of Appeals lacked jurisdiction over the appeal of the criminal judgment, though?
No, not at all. The defendant properly gave notice of appeal orally after the criminal convictions, and in fact included in the record, as I said, that was clarified that was intended to be for the criminal.
Okay, I just wanted to make sure that I wasn't missing something on that.
No, I actually looked at that too, because in order to look to see whether any of us are missing something about whether the defendant properly gave notice of appeal, or at least tried to, that was something I would imagine that all of us would want to look at. And I did that as well. But not only did the defendant not give notice of appeal orally or in writing, and has specifically made that clear in the record, also in looking at the record, you can see that while the defendant, of course, is not tied to the potential issues raised, assignments of error at the end of the record, of those 18 potential issues the defendant has listed, none of them involve SBM. So it does not appear as though the defendant at that point did in fact intend to appeal the SBM order. There's certainly no indication that he did, and he didn't take any steps. Even when he filed the petition, he did not try to make an untimely, at least, written notice of appeal. So without the notice of appeal, the Court of Appeals was without jurisdiction, even though it had taken this extraordinary step of granting the defendant Rule 2 review to address the waiver problem. But the problem with granting the extraordinary step and the special discretionary review under certiorari is that discretion is not triggered unless there's actual merit, and there's not merit here. Also required is diligence. So as we've just been discussing, the defendant made absolutely no effort whatsoever to appeal this case. In fact, to appeal this SBM order. And in fact, he made, of course, gave no diligence at all to preserve the issue. Again, unlike Bursell, the defendant didn't raise any objection whatsoever to the SBM order, where Bursell didn't raise a constitutional objection, but did raise some objection. So the Court of Appeals error here is in extending two extraordinary measures to overcome what are supposed to be our mandatory rules, which should be in place unless there is a rare reason to do this, an exceptional reason to do this. And that does not exist here. In fact, what we can see from the cases that the defendant has cited in defendant's brief is this has become a matter of course now. Exercise of Rule 2, and now, based upon this case that we are reviewing today, the Court of Appeals is now invoking certiorari and Rule 2 routinely to vacate SBM orders that defendants do not challenge in the trial court and do not appeal. In fact, the case that specifically cited this one, I believe that's Ellis, granted certiorari review ex mero moto. So what we see is that the Court of Appeals is granting Rule 2 review as a matter of course and based on precedent. There's not really a lot of confusion about that here, because what the Court of Appeals did is it explicitly said that it was granting Rule 2 based on these Bursell factors that it found, which is really the same mistake the Campbell 2 court made in invoking Rule 2 based on Gate and Barbosa. So in this case, the Court of Appeals has taken that error in invoking Rule 2 based on precedent, which it may not do, and also invoked and used certiorari review where there's no diligence and no merit.
Sorry to interrupt. I just want to make sure I understand. The standard of review on both these issues, whether it was proper for the Court of Appeals to grant certiorari and whether it was proper for the Court of Appeals to invoke Rule 2, it's an abuse of discretion standard. Am I right about
That's
that?
correct. Yes.
And then just exploring a little bit more the difference between Bursell and this case. Am I correct that in Bursell, the state took the position that it was error for the trial court to impose satellite-based monitoring without having a hearing on the reasonableness of it in that case?
So I argued Bursell, and the state's position was that the state had conceded error below, but the error that the state had conceded below was that it had not, in fact, had the hearing, the extended Grady hearing that the Court of Appeals had held was required. But the state still contested that that type of extended hearing is required. And that is something that the dissent in this case spoke about as well.
So there was no hearing either in this case, though.
Well, there was a hearing. So there was not an additional evidentiary hearing. But once the defendant was found guilty by the jury and sentenced by the trial court then entered a hearing to determine satellite-based monitoring as well as registration.
Right, but there were no findings by the trial court about the reasonableness of imposing satellite-based monitoring in this case.
That's correct. There were no particular written or oral findings that were stated. But not only was this a case unlike a bring-back hearing, this was a case where the trial court had just heard all of the evidence at trial. So there was a plethora of reasonableness to grant this order. And additionally, the trial court here did what does not normally happen in Superior Court, was in fact the fact finder in this case. So the trial court did definitely receive information about reasonableness, as well as the information which is required for the trial court to actually enter an SBM order. So the trial court did what it was required to do and following the law, the statute, and it found that the defendant had in fact committed 5 aggravated offenses against children, which qualified him and in fact mandated under our law that the defendant submit to satellite-based monitoring. So there were findings made, and there was information that was that demonstrated reasonableness, but there certainly was not the extended Grady hearing that would have perhaps involved some additional offering of evidence. That evidence was already before the court.
Counselor, I know you're getting close to your rebuttal time, but I did want to clarify what you just said to my learned colleague, Justice Earls. You mentioned there being an abuse of discretion standard of review concerning the Rule 2 aspects of this case, but in your brief, you say that the standard of review is error of law, which I thought may go towards your lack of jurisdiction argument. Are both of these standards in some fashion in play here, or is one to supersede the other?
An error of law is an abuse of discretion. When an appellate court acts in contrary to the law, that in fact is a showing of abuse of discretion. And what the Court of Appeals did here was in fact an error of law and of course then an abuse of discretion, because it did precisely what this court already held it may not do. It may not base a decision whether to invoke Rule 2 based on precedent. And that's what it did here in finding these Bursell factors and in fact announcing that it made that decision based on consideration of those factors in this prior case, that being Bursell.
So you're using error of law standard of review and abuse of discretion as a standard of review interchangeably?
Well, I believe that an error of law is an example of abuse of discretion. Certainly error of law can mean other things as well. But when we're looking at trying to define an abuse of discretion, an error of law is one of those definitions, Your Honor, yes.
Does it include your jurisdiction argument as well then? As to the error of law standard of review?
I'm not sure I understand the question. So the certiorari review is, I see what you mean. So certiorari review, of course, also is an abuse of discretion. But yes, so in order to trigger the opportunity to exercise discretion to use to grant a writ of certiorari, there has to be merit. And there's not merit here. One, there's not merit here because there's waivers, so there can be no merit. But two, there was also no merit because this court, in addressing this defendant's potential for falling under Grady, which is what the defendant has relied on, this court actually specifically stated that Grady did not apply to any of the parameters upon which this defendant falls, because he is still subject to state supervision. And this court specifically said that Grady did not apply to aggravated offenders, which this defendant is, nor did it apply to offenders who violated and committed sex crimes against children under the age of 13 as an adult, which of course the defendant, that's precisely the 5 offenses the defendant was convicted of here. So yes, the Court of Appeals not only abused its discretion in invoking Rule 2 improperly, it abused its discretion in authorizing certiorari review and basically bending over backwards to vacate a trial court's order that the defendant, in fact, did not raise any objection to at all and did not appeal.
I don't want to, Ms. Postel, I don't want to split hairs with you, but I want to make sure I understand the argument. In your view, does there have to be a showing of absolute merit or just arguable merit in order to support the allowance of a certiorari petition?
No, you're right. It has to be merit or probable merit. But we can't.
So you're not saying that the defendant has to show that he or she is definitely going to prevail in order to obtain a properly issued writ of certiorari?
No. Yeah, no, I don't. I think the case law supports that there has to be either merit or probable error, but the defendant can't show that here. With waiver, that just is an impossibility. And then when we look further at the merits, this defendant would be.
So again, I'm afraid I'm going to lose your train of thought if I don't ask this question. Are you then saying that it's inappropriate for an appellate court to ever grant certiorari in the event that a claim has not been fully, properly preserved?
I can confidently say that I don't think it should be. I think if there's waiver, then there can't be merit, and there also has to be diligence. And I think that waiver goes to both of those two prongs.
So it's your argument that certiorari is only available for fully preserved claims.
I do think that would be fair, but I don't think you have to go that far in this case, because in this case, the defendant didn't even attempt to raise any sort of issue, not about SBM at all, not any kind, not constitutional, not statutory, not as applied, not facial, none. And so there's no diligence and there's a complete waiver. And in addition to that, there's a complete absence of appeal. So in this case, not only was it an abuse of discretion to invoke Rule 2, it was also an abuse of discretion to grant certiorari review. And certainly in granting both of those, where the defendant has failed at every level, that is not what these extraordinary measures are for. The mandatory rules can't be mandatory unless they are required to be used. And in granting extraordinary measures repeatedly as a matter of course, this is doing just what this court warned about years ago. It is making the use of our mandatory rules meaningless, and it is incentivizing a party's decision not to, in fact, raise issues at all at the trial court level, because it puts the defendant in a better position on appeal. They're not now limited to whatever they argued in the trial court, that specific argument. They're open to argue anything they want. And in this case, the Court of Appeals is arguing it for them. So the Court of Appeals did err in this case. And if there are no more questions at this time, I would just ask that this court respectfully reverse the majority opinion on this issue, which vacated the trial court's unchallenged, unappealed order, leaving it intact. And I'd like to reserve the remainder of my time for rebuttal, please.
Thank you, counsel. We'll hear from the FLE.
Good afternoon, Your Honors. May it please the court, Chief Justice Newby, justices. My name is Kim Hoppin, and I represent Johnathan Ricks. I would like to initially, I think I need to correct this record here. This was a jury trial, and the record includes the charge to the jury and the jury's verdict. So I don't think, unless I'm misunderstanding what Ms. Hostel said, I don't believe this was a bench trial. Having said that, one of the notes I wrote when I was first crafting my argument for this case was that it does appear that what the state is asking this court to do in potentially overturning the majority opinion here is to make a bright line rule that it's always an abuse of discretion to grant the petition for the writ of certiorari if the court has to reach the issue by invoking Rule 2. And I just don't think that there is that we don't have that in our case law or in the statute. There is no bar to this court's discretion to grant the petition of certiorari under those circumstances. In this case, the court exercised an appropriate discretion. It conducted a case-by-case analysis. If we look at Ledbetter, the General Assembly has determined that the court can exercise its constitutional authority to issue these writs. And it empowers the courts to do that unless there's some statute specifically restricting that authority. And it is true that precedent does not create an automatic right. And, you know, we had this unusual situation where we've had case after case after case, not following the exact same fact pattern here, because in some cases there was a written notice of appeal, in some cases there was not a written notice of appeal. What is present in a lot of these cases, and in this case in particular, is that the state did not attempt to conduct a hearing, did not present any evidence whatsoever. The trial court did not make any finding about reasonableness of the satellite-based monitoring order in this case. The order was entered based solely on the nature of his conviction. And
Well, is it your contention then that a defendant has no obligation to raise the Fourth Amendment reasonableness issue before the trial court? That there's error regardless of whether the defendant asked for such a hearing?
I think the defendant is required to preserve the issues under our statutes. What is unusual about these satellite-based monitoring cases is that in this case, you had a defendant who was indigent and represented at trial. He's not even able to raise the issue of ineffective assistance of counsel for failure to preserve what is otherwise a meritorious claim under the precedents of this court.
Well, let me ask my question again.
Okay.
I didn't ask it very clearly. Is it your contention that regardless of what the defendant does or doesn't do, the trial court has an obligation in all satellite monitoring cases to convene a Fourth Amendment reasonableness inquiry?
I think that our precedent places the burden on the state if the state seeks to have the order imposed.
So is the answer to my question yes?
Well, I think in every case that the state seeks an imposition of lifetime satellite-based monitoring, I think our case law places the burden on the state to demonstrate reasonableness and on the trial court to find reasonableness. I think it's a separate issue whether our appellate courts are required to review an unpreserved claim about that reasonableness.
If the trial court has a mandatory obligation in all cases to conduct such an inquiry, even if the defendant doesn't ask for it, is that how, if there's such an obligation exists, how is any claim not preserved? I'm just not following your position. It may be that I'm just not understanding correctly. Are you saying that it is error for the trial court not to have a Fourth Amendment reasonableness hearing in all satellite-based monitoring cases?
I think Grady sets out. So short answer would be yes. I think Grady sets out that the imposition of this lifetime satellite-based monitoring is an intrusion upon a defendant's right to privacy, that it is unreasonable unless supported by it's unconstitutional unless supported by reasonableness. And it places the burden on the state to demonstrate that reasonableness. And it says the trial court must make those findings. I think that we layered on top of that, though, is also a mandatory, this situation about waiver, and that constitutional claims unpreserved are waived. However, we do have a way to reach those claims, and that is a case-by-case analysis of whether it's appropriate for this court or the Court of Appeals to use their discretion and invoke Rule 2 to reach these claims. I think it's clear that this is a problematic situation with these satellite-based monitoring cases. I believe the case that was heard before this one also involved a similar issue, Graham. And there are a plethora of cases that came before this one and after this one.
Let me ask you something about the procedure here. As I understood the record, the orders, the judgment and then the SBM order entered by the trial court at the end of this trial, and there are jury verdicts in the record, so it looks like it was a jury trial, came in January of 2019, which was several months before our court's decision in Grady. And it looked to me like the petition for cert in the Court of Appeals was based in large part on Grady. Is that having been decided? Is that accurate?
I haven't reviewed those exact dates, but if that's what you're seeing in the record, then that would be accurate.
Is it significant to your argument that the trial court's judgment and orders here were entered before the decision in Grady, in terms of the Court of Appeals' discretion to look at those issues after Grady?
Well, I think one of the things that the court talks about is having the benefit of, that the court had the benefit of prior precedent in knowing whether they did or did not have to conduct a hearing. And just trying to think if that makes a difference in my argument.
Well, if we're reviewing what the Court of Appeals did in allowing the petition for writ of cert as whether it was an abuse of discretion or not, that would be something that we could take into account in looking at whether their exercise of that discretion was reasonable in light of standard of review, correct?
Yes, of course. So I sort of divided this into, there are sort of three issues. There's the discretionary allowance of the petition. There's the discretionary invocation of Rule 2. And then there's the argument about the merits, which we don't really get to in a case like this because there was really no hearing and there was really no reasonableness presented. And I would just argue again that here, this Mr. Ricks had the right to appeal this order. He did not enter the written notice of appeal. He was represented by counsel when he did it, or when he did not do it. So, but he can't claim ineffective assistance of counsel for that failure. But he did enter notice of appeal to the judgment in this case, which I think most defendants would assume would include the order that was entered at the same time as the rest of his judgments. The issuing of the writ it confers jurisdiction, but it's a separate issue. It doesn't cure any of the other procedural violations, which was what we're talking about when we get to waiver. And I don't think that you can equate a failure to preserve a claim with a statement that that claim has no merit. This is a meritorious claim that wasn't preserved. And that is why we have Rule 2, is to prevent manifest injustice to a party because of a failure of the party's counsel or a misunderstanding of the law to reach an otherwise meritorious claim.
Ms. Halpin, I'm sorry.
Go ahead.
No, go ahead, Justice Urban.
The question, I mean, this is a variant of the question that I asked you earlier, is the meritorious claim that wasn't raised, the trial court's failure acting on its own motion to have a Fourth Amendment reasonableness hearing? Or is the alleged error that the trial court reached an incorrect result with respect to a reasonableness inquiry?
That's a very interesting question. I mean, I haven't really thought about it all the way across the board. Is there ever a situation where the court could enter a lifetime monitoring order under the facts of the case before it without making a reasonableness finding? It seems to me that the court's precedent, the case law, the reasoning behind why this inquiry is necessary, it seems to mandate that this order cannot be imposed without a finding of reasonableness, and that it's error for the trial court not to make those findings. It begs the question for me, which I have not researched, is would there ever be a situation, has any other jurisdiction found a situation where a reasonable determination could be made just on the facts of the case, but we don't have that here, certainly. In this case, the state was seeking to impose a lifetime satellite-based monitoring order. It did not present any evidence to support that order that it sought, and the trial court made no findings. And the order, it got imposed in violation of Mr. Rick's constitutional rights. And he didn't enter notice of appeal in the correct way. I certainly acknowledge that. That's why a petition for writ of certiorari was filed, and acknowledging that very thing. Does that answer your question?
I think I understand your point. Yes, ma'am.
You can see that our case, State versus Grady, does not include the folks that this defendant is a part of the class. In other words, Grady on its face said it was applying to a particular group of defendants, and this defendant, Mr. Ricks, is not in the Grady classification. Would you agree with that?
Yes, I would agree with that. I think Grady is directed towards recidivist, if I'm separating my cases correctly. In this case, the order was imposed not based on any particularized findings about this defendant, but based on the nature of his offense solely. And the reasoning behind Grady applies here as well, that there isn't some individualized analysis of why this particularly burdensome intrusion onto his privacy is justified, and the fact that there are these unknown future circumstances that the court can't really determine when they're imposing a monitoring order on someone who won't be released from prison for 3 or 4 decades. I think the reasoning behind Grady that caused Grady to apply the reasonableness requirement for that particular class of defendants also applies to this class of defendants too, where there's just been no individualized reasons to support the state's need to monitor this particular defendant in the future, and how that justifies the state's particular interests.
But you can see that the case itself, Grady doesn't include the category that this defendant falls in. And in fact, there have been no cases from this court addressing with finality the class that this defendant falls in.
Yes, no cases from this court. There have been other Court of Appeals cases applying the reasoning of Grady to the class of defendants that this one falls into. But yes, I would concede that this court has not fully addressed that. And I think that that's why there are several of these cases before this court now, to achieve some finality in our jurisprudence on this issue.
This case has a number of layers, obviously. Looking at the Rule 2 layer, to revisit that one for just a moment. In State versus Campbell, this court said that Rule 2 relates to the residual power of the appellate courts to consider, in exceptional circumstances, those kinds of issues that would appear to prevent manifest injustice. While certainly manifest injustice being prevented is important in any case, but what would make this particular case fall into the category of having exceptional circumstances?
Well, what Campbell talked about, looking at the specific circumstances of the case, of looking at Campbell listed a lot of factors that they looked at: the age of the parties, whether there was a substantial right involved, which there certainly is one here, They looked at the factual basis, the nature of the charges. And one of the things that they looked at in the cases that follow those Campbell procedures is whether the state and the trial court failed to follow well-established procedures. And that certainly happened in this case. I think what makes this a considered decision, what makes this the exceptional case, is that there is a clear constitutional Grady error in this case. There was no hearing, there was no finding of reasonableness. It's doubtful, based on the precedent of this court, that the state is going to be able to make, based on the analysis that has happened in Grady and in other jurisprudence on this issue. It's doubtful that the state's going to be able to make a reasonableness argument that passes muster about imposing satellite-based monitoring, lifetime monitoring on someone 40 years in the future. Like how, so I think that makes this case exceptional. If you look at, I'm not entirely sure. I know what I think when I look at the court's writing about the nature of the charges, the ages of the defendants. I'm not exactly, it's hard to be in someone's head and know what they mean by that. I mean, rape is rape, but there are different kinds of rape, I suppose. In some cases may be consensual, but for the age of the parties involved, and obviously a young child can't consent. But these two girls in this situation, by all accounts, but for their age and immaturity, were chatting with this defendant on a regular basis as well. I don't know if that's the kind of thing that the court is contemplating when it talks about the nature of the offenses. They talk about the age of the defendant, though, and in this case, the defendant is a very, very young person. Obviously an adult under our legal standards, but a young person who will be facing most of his life now in prison, and that certainly makes this an exceptional circumstance.
The dissent looks at the defendant in the Bishop case and compares that defendant to the defendant in the instant case and observes that there is really no difference in the posture of those two respective defendants when it comes to exceptional circumstances. What would you say in response to that?
What I thought was that the defendant was being compared to the defendant in Bursell, but in Bishop, that was a case where the court below declined to invoke Rule 2, and they set out the petition must show merit, and that error was probably committed. And the notes that I made to myself about what changed after Bishop that would allow a court to then invoke Rule 2 in a situation where they had not prior was that the law has become very unsettled. I think Bishop was handed down in 2016 or 17, and since then we've had all of this activity on this particular satellite-based monitoring issue and on whether the court has to find the reasonableness and what constitutes reasonableness. The court below also decided Gordon, which did squarely address this particular situation about the aggravated offense being what places the defendant under the lifetime satellite-based monitoring imposition.
The Bishop case is a Court of Appeals case. Obviously, we're not bound by it, but since you talk about the interim case law being generated, are you advocating that Bishop be overruled, or does that Court of Appeals case still have some merit in your view?
I think the Bishop case points out the same thing that we've sort of been discussing here, that both well, that there has to be an appropriate exercise of discretion. And I think what Bishop sort of says is that we can't just exercise this discretion in every case, that we can't just exercise this discretion because it's a constitutional violation. There has to be something more. And I think that for that proposition, Bishop is okay. I think, though, that cases that have come after Bishop, what they have distinguished is that the law on this particular issue is in flux. And that is one of the valuable reasons for our courts to exercise their discretion, is to settle an unsettled area of the law. And I think it is definitely fair to say that the law surrounding the imposition of lifetime satellite-based monitoring and the reasonableness required for that is not at all settled at the moment. And so I would say that while Bishop stands for some important propositions, it's not difficult to distinguish later cases from Bishop.
Ms. Hoppin, if I can, I would like some help with procedure. So before granting a petition for writ of cert, an appellate court must find some failure on the defendant's side that was not a result of his actions, right? And some merit to his argument. Is that correct?
Well, I would say that there certainly are situations where there's a pro se defendant who files an improper notice of appeal. So he has lost his right to appeal because of his own actions. So I don't know that they have to find no fault. But they have to find that there is some merit in the petition, that he's lost the right to appeal because of some action, whether his own and his attorneys, lost in the mail. There are lots of reasons why notice of appeal doesn't get entered correctly. And that there either he can show merit, or that error, the way it's phrased is that error was probably committed below. And I don't know, I know that earlier there was a discussion when the state was presenting its case about whether there is a requirement that the court find an absolutely meritorious claim. I don't think there's a requirement that the claim has to be preserved for the court to issue its writ. I think it can exercise its, yes.
Okay, and so turning to Rule 2,
Yes.
the text of Rule 2, and you've gone through, and counsel for the other side, your friend on the other side has as well, gone through most of the rule, but there's this provision towards the end that says court may suspend or vary the requirements or provisions of any of these rules in a case pending before it. So would under the text of the rule, consideration of manifest injustice and those things on the front of Rule 2, would those be improper in considering whether to issue the petition, the writ of cert?
I don't believe so, because I think the court can consider the petition for writ of cert as a jurisdictional issue. Can it exercise its discretion and invoke jurisdiction to hear an appeal? And then as it's looking at the appeal, it looks at the procedural, is this issue preserved or not preserved? Is there merit to this issue or not merit to this issue? I don't think that those two things, I don't know that there's any requirement that they have to be exercised at the exact same moment. I think there's nothing wrong with the court extending jurisdiction and then examining this waiver issue and considering, I just don't think you can equate waiver to meritorious claim. You can have a meritorious claim that was unpreserved because of ineffective assistance of counsel. I mean, that's not applicable to this particular situation, but you can have a meritorious argument concerning sufficiency of the evidence that was unpreserved because counsel didn't object. And so I think the court can, issue a writ because of a faulty notice of appeal to then examine a meritorious claim, unpreserved sufficiency claim. And this is.
But I'm sorry, if an appellate court were to examine manifest injustice in granting the petition for writ of cert, you don't think that would be inappropriate?
It's hard to say that the court, it would ever be inappropriate for the court to consider manifest injustice. I mean, I don't think that I don't think that Rule 2. I think that how do I say this? The analysis of the appropriateness of the exercise of discretion for the petition for writ of cert is quite similar in the case law, but not exactly the same as the analysis for the Rule 2 exercise of discretion. They're both discretionary. I just think one looks at the more jurisdictional features. If manifest injustice, I don't think they're required to consider it. I think there's nothing wrong if the court does consider it.
Okay, thank you.
Yeah, thank you. Does anyone else have other questions? So again, I would ask this court to affirm the majority opinion of the Court of Appeals, which vacated the satellite-based monitoring order in this situation. I would point out that the state is not prejudiced in any way by a remand here. It would then be ordered to do what it was already required to do and just didn't do in this situation, which is to hold an additional hearing. I have noticed in the few cases that have come down through the trial courts after this, that often judges are deferring the hearing on the imposition of a lifetime order until the defendant is released from custody, which is certainly seems to be a more efficient way of doing all of this. But I would just point out that the state isn't prejudiced by remand. Thank you so much.
Thank you, counsel. Rebuttal.
No, thank you, Your Honor.
Thank you. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina will be in recess until 9:30 tomorrow morning. God save the state and this honorable court.